What's up, guys? Welcome back to Kitchen Court Cases, where we watch court in my kitchen. And today I have a very interesting hearing for you. Um, I started watching it and recording it and was quite fascinated by the question that is posed to the court. Um, just as my usual pre-warning, this is a cock block case, which means that there's no resolution. It will be discussed further on another day, but I think it's definitely worth listening to.
Good afternoon, Your Honor. AAG Helen Kelly here on behalf of the Dental Board.
Mr. Houston, you are muted.
Sorry about that. Thank you, Your Honor. I'm Fred Houston, representing the defendant, John Doe.
And then we have somebody else with us. I'm not for sure if he wants to make an announcement or doesn't want to make an announcement.
That's a witness for the board, Your Honor.
Thank you. So, I've never, I don't think, seen a proceeding like this one. And so I've been looking at some of the paperwork and the pleadings. So before we get started with witnesses, if both sides could explain to the court what they're looking for today, what the purpose of this hearing is, and what the purpose of the lawsuit is, because both I've never seen in 13 years, and it was a central docket case, so I've only been looking at it for a little bit of time. So explanation would be helpful, and I suppose we will start with Ms. Kelly.
Thank you, Your Honor. This is a unique type of case. The only
That makes
purpose,
me feel better.
yes. The only purpose, and I guess perhaps Mr. Houston, if you want to chime in, out of an abundance of caution, these are confidential proceedings, and so I think normally they would take place in the chambers. I think we can try to have as much out in the open as possible.
So that's a really interesting question from the beginning, because I've never done that before. And so if somebody is going to ask me to seal a court, one, I'll be honest with you, this is not the way to do this, because y'all should come down physically to the courthouse where there is open courts, but not an open YouTube channel. And it's perhaps easier to have this communication. But two, that really is a question of first import, is what I can do and cannot do with a state that has an open courts constitutional provision, unlike the federal court system. And I see there's a U.S. code statute cited here, but unlike the federal courts, the Texas courts have to remain open. And so if we're going to seal something, it really is an issue of first import, what and how and whether that can even happen. And I would need to see some pretty strong case law that we can seal a courtroom from anybody who would want to see it.
Right. And we're prepared to go forward and refer to the defendant as John Doe. And I think, with the exception of perhaps some documents and evidence that we might request that you look at in camera for the rest of the proceeding to be open. But Mr. Houston, I also want to be cognizant of your client's interest if you feel there are provisions of the law that would otherwise make it confidential.
I do have concerns because you're right, this is very unique, and there's not a lot of law, quite frankly, with regard to this. There's very limited law in the United States, and so in Texas, it's even more unique, as it is in a lot of other places. But the Code of Federal Regulations, it's 264, talks about how if this bypass, which is basically what's happening here, there's a request for the court to sort of approve or confidential substance use disorder records to be
I'm gonna,
released.
so hold on.
And so
So,
this is the.
nope, stop. Your feed is very garbled and it's very hard to take the record, Mr. Houston. The connection's bad. And when you started talking just then, it got all messed up. So I believe you were saying that there is something under federal law that this court needs to look at. And so I do see that. I guess I'm trying to make sure that federal law contemplates a state court lawsuit. Is that what federal law contemplates, a state court lawsuit?
What it says is just a court of competent jurisdiction.
Of
And
what
so-
jurisdiction? Of, again, we are
Competent.
getting competent.
Yes. Yes, the court of competent jurisdiction. And this issue came up in the SOA hearing, the administrative hearing as well. And so in order for it to be addressed, apparently the State Board of Dental Examiners decided to have this formally come before a district court judge, which for Texas purposes certainly is a court of competent jurisdiction to be had.
For what
obviously-
purposes? I'm gonna have to keep kind of asking you. There was something for something purposes, but I couldn't understand that word.
In order for them to have, it's a judicial bypass that will allow them to have access to a patient's substance use disorder records. And so as it's contemplated under 264, there is a confidentiality provision that says that this technically would be heard in chambers, or at least in a manner that is confidential.
What is
So,
264? I don't know what that is.
42 CFR, Code of Federal Regulations, 2.64.
Right, but I think I'm just gonna play devil's advocate for a minute, having just gotten this case earlier. I don't know that the Code of Federal Register controls anything that I do and talks to me at all about whether I can go in chambers on something. I don't believe that the Code of Federal Regulation controls what a trial judge can do at a state district court level in Texas. I understand, Ms. Kelly. I'm just trying to understand this case. It sounds like y'all are currently in the middle of a SOA hearing, and rather than deciding it at SOA, you have filed something here in Travis County State Court to have a Travis County State judge decide it under federal law.
Yes.
And what
And
would give me any jurisdiction to hear this matter?
I think the fact that this is a court of competent jurisdiction, I will say in my application, we make reference to other cases, child, I guess, custody proceedings that have been held in Texas were similar.
There's a specific part of the family code that allows me to make some specific findings under the Texas Family Code to seal the courtroom when it involves a child.
Okay.
So that's, so I don't know. I mean, I can take things on camera and I can look at things in camera. I do that all the time. In the closest, I think, comparison would be a proprietary interest, some sort of trade secret. Obviously, we do that, but we don't seal the courtroom. The lawyers make their arguments for the record, and the court takes a document in camera or documents in camera and makes a judgment call about whether those documents can be sealed or not under the Rule 76A, which is really the order to seal records in the civil rules of procedure. That's the closest analogy, really, in Texas court. So what is it that you filed a lawsuit, which it's weird in and of itself. It's, you filed a lawsuit for the court to do what? Make a declaratory judgment action?
To enter an order granting the board access to John Doe DDS's substance use records.
Do you not have those already?
No, we do not.
Then what did I get? I got something that I thought your side provided that was an in-camera record.
We provided an affidavit from a social worker, Mr. Attorney, who spoke to the defendant. We believe the defendant, independent of the substance use facilities treatment records, disclosed that he had a substance use disorder. That's Exhibit 1. Exhibit 2 details the agreement, the consent for services agreement that he entered into with the Professional Recovery Network. And so this was in response to the defendant's motion to strike. But essentially, we're arguing that we have a right to the records under the exceptions provided by in the federal law, because there's no other way for us to obtain his patient records, and that it's in the public's interest.
Why would this not be a question? I guess you're claiming you could do it either place, in state district court or in federal court. I mean, I'm trying to figure out why this is a state court issue. I understand you're in a SOA proceeding, but I guess I'm trying to figure out, never seen a case like this. Do you also have jurisdiction in federal court, or do you think you only have jurisdiction in state court?
Honestly, it's a unique type of case order, and we went back and forth about which court to file in. I think we're leaning towards Travis County because they have familiarity with the administrative hearings process at SOA.
So the other locations were maybe the venue of where John Doe is, and also federal court. But you don't think that you don't think that SOA can handle this on SOA's own?
No. So, there was a temporary suspension hearing previously, and they determined they did not have jurisdiction. And I think it's been settled. And there's also case law referenced in our application that they are not a court of competent jurisdiction.
To be clear, federal law says that these records are confidential unless they are met with a particular exception. Now, obviously, our argument is that they don't meet any of the exceptions under federal law. And in particular, it's 42 USC, it's 290 DD-2, and subparagraph C restricts the use of these substance use type of records. And it specifically says, except as otherwise authorized by a court order under subsection B2C, or by the consent of the patient. A record referred to in subsection A or testimony relaying the information contained therein may not be.
Mr. Houston, we've lost you again. One of the reasons I keep cutting you off is I get about every fourth word for you, and Miss Braccanelli is just having to put inaudible because we lose you. So
okay.
I think what I'm hearing is you agree that this court might have jurisdiction to hear this matter, but you would like the court to deny Ms. Kelly's request for the court to order these to be provided? Or do you
believe that they don't
jurisdiction?
Right. I don't question the jurisdiction. What I question is whether or not their request is proper and can be granted due to the lack of consent, because this is all about consent and whether they complied with federal law. Their arguments are that they complied with state law. We're arguing the federal law because it's federal law that governs this particular area and puts in very strict requirements. We believe they can't comply with that.
Is this,
And we disagree with his interpretation of federal law and its applicability to PRN. And then also as a bar, I feel like he's bringing in criminal doctrine, the fruit of the poisonous tree, the previous SOA case, neither of which are applicable at this time.
is there a current SOA case, or is that currently, is there a case currently open at SOA or no?
There's been a case filed. It is pending the outcome of this so that the records can be brought before.
And that is a pending State Board of Law Examiners case. That's some sort of action against the dentist at issue.
Dental examiners, but yes, essentially, as Mr. Houston stated, the defendant can consent. If he doesn't consent, the board has no other way of obtaining the patient's records other than by this court order. The board also went to the trouble of requesting that Mr. or Dr. Doe undergo a mental health evaluation for substance use disorder issues, and he declined to do that as well. And so we're arguing that under the prongs of the federal regulations, there's no other way for us to obtain this information. But we know that there's an issue because he self-disclosed to Mr. Turner at the Professional Recovery Network, which Mr. Doe is the source, or excuse me, Dr. Doe is the independent source of our knowledge of his substance use disorder. And that we need this record in order to protect the public's health and safety, because without it, he continues to practice.
Your Honor, there is no, well, first of all, to be clear about the hearing, there was a prior hearing. SOA basically issued their determination that these records cannot be admitted into a SOA administrative hearing unless there is a judicial bypass under federal law, and that bypass has to come from a court of competent jurisdiction.
Has somebody provided me that ruling made by SOA? Is that in any of, made by the SOA judge? Do I have that to look at anywhere? Was that a written order of some sort, or was that just issued? Was that just said?
It has not been provided, and we would argue that, you know, it has no basis on this current proceeding.
Other than the fact that it's what's telling me I'm supposed to do this.
Ideally, what should happen is that, and the problem that we have here is that the judicial bypass that they're searching for today should have happened first before the records were provided or disclosed by PRN to the board. That's the problem. And so they're here now asking you for this judicial bypass after the fact, which is why they have a lot of problem with me making the reference or sort of the analogy to the fruit of the poisonous tree. They've already violated federal law by disclosing records that have a federal prohibition against disclosure. They do not have consent or a consent form that complies with federal law under the law that they're filing here today that governs this. Their consent is insufficient. And so they assumed that it was sufficient. And when John Doe decided that he did not want to be in the program or have anything to do with PRN, and he didn't have to because he wasn't under a board order.
You're saying PRN? You're saying, I don't know what that is. You're using an acronym that I don't know.
Yeah, PRN is the Professional Recovery Network. They are a sort of a program that works in conjunction with various state agencies, one of which they work with is the Dental Board. They work with the Texas Pharmacy Association. And so they basically do some monitoring services on behalf of those agencies for various different issues. But for mental health, for substance abuse, it is a program that assists with that. The problem that we have here, though, is that in order for them to have legally made this disclosure to the board has no knowledge whatsoever of my client or his any type of connection to a treatment facility, but for the fact that he got clear. and I can give you the citation, under,
If I may respond before.
Hold
we
on,
go
let me
forward.
let Mr. Houston finish because his connection's so iffy. And so before you go into that, let's hear what he's gonna say and then we'll come back to you.
sure, it's under CFR, 42 CFR 231A 6 and 7. Those two provisions say that any type of disclosure dealing with substance use records has to have a warning to the patient. They have to let them know that it's revocable, and they have to tell them what time that consent move forward. It's very clear. And after that, 231 Part B says that if the consent does not comply with Part A, the disclosure is not valid. They can't get past that, period. No matter what they say, no matter what disclosures they've provided, they're not going to comply with federal law. And so they can't do it. But they made the disclosure anyway. And so now we're saying that disclosure is illegal. And
But I don't know that that's this case though, Mr. Houston. I'm gonna be honest with you. It sounds like she's brought a case to for me to order some disclosure, not determine whether a previous disclosure was proper or not. But maybe I misunderstood what you were saying, Ms. Kelly. Go forward now.
No, that is correct, Your Honor. And essentially, the record that Mr. Houston and the defendant complain about us trying to offer, we're not offering. We've gone ahead and included that as Exhibit 3 for your in-camera review. That way you can take a look at it. But it's essentially a letter from the rehab facility to PRN outlining diagnosis, treatment recommendations, etc. And that was sent unsolicited to PRN from the rehab facility. Now, if there's some sort of disclosure that Mr. Houston is referring to, it might be in the patient records that InterHealth has that would cover it in their communications, but we don't know that because we haven't seen the patient records. Regardless, we're not trying to enter in this single letter from a date and time. We're interested in his patient records, and hopefully there's something more recent that can tell us about his compliance, non-compliance with this treatment, his current diagnosis, if there is one. And so that's what we're looking for, the actual patient records. Also in our application, we go into the fact that—
my confusion is, I'm gonna interrupt you now because we see, obviously, I've been doing this 13 years and we see a lot of appeals out of the medical examiners, the dental examiners, the chiropractic examiners. It seems like this is the sort of issue that there's probably a lot of established rules and case law about what records that these state agencies are able to access of licensed healthcare providers. But then I don't understand, I guess, why this case is different. I'm trying to figure that out on the fly, but there's no case law about this. There's no comparative decisions about issues like this regarding mental health, psychological health, physical health of doctors, psychologists, dentists in the state of Texas.
I think this is the one area where Mr. Houston and I would agree that there's very limited case law, and it is surprising that there hasn't been a definitive ruling on this issue before. But there's really
nothing in the federal law either, or are there federal cases involving interpretation of CFR 231 and CFR, I guess it's, and then of F42 USC 290. I mean, is there anything out there that would help the court with that?
To the extent that there is, it's been cited. I think, we tried to find a case regarding a medical provider, and we've pulled up something from the Supreme Court of South Carolina I think Mr. Houston's cases are not applicable because they tend to refer to criminal matters, and there was no search, no seizure here. And so we would dispute their applicability in this instance. And I guess just getting back to PRN, it is the Professional Recovery Network. It is a state-run creation for physician or pharmacists, dentists, and other providers in need of treatment and to monitor their compliance. And it's funded by licensure fees from licensees from these various agencies. And so we don't believe that they are a Part 2 agency that is necessarily bound by these federal rules. And so when Dr. Doe self-discloses to them, that has nothing to do with his treatment by InterHealth. And the confidentiality provisions therein, you know, we have an independent knowledge for him being in a rehab facility, but that's here nor there. We think the fact that he's a physician, that he's impaired, that presents good cause to the court to grant this order for us to obtain his patient records and to move forward with the SOA case.
And so, again, I've not agreed to look at anything in camera. I have not agreed to admit anything under seal. That would be improper right now under Rule 76A. Somebody's going to have to explain to me why in a Texas state court I can do any of that. And so what I think we're going to have to do is reset this for an in-person hearing where some thought is given to what I can do in an open courts state and what I can't do in an open courts state. And if you want me to look at documents under seal, you're going to have to figure out Rule 76A, or you're going to have to, because the issue that you're going to have in this case, I'm just going to tell you, is you're going to fight 76A, because the thing that I have to find to rule something is sealed or confidential in civil court in Texas is I have to rule that it's not a matter of public health and safety. And the issue you're going to find in this case, of course, is that's entirely what it's about. And so somebody's going to have to explain to me if I'm going to can I do this in Texas state court? So my suggestion is try to find anyone, anywhere, including on our dockets, who've had a hearing like this before, and some guidance for the court about what I can and cannot do in a sealed or confidential proceeding. Because right now, I'm a little uncomfortable proceeding without some guardrails around what would be proper and not proper.
I think that perhaps the best course of action may very well be federal court, to be honest with you. Because at that point, a federal judge is going to be dealing with federal law.
And they have a lot more discretion than I do to close things. This court has no real discretion to close anything. And in fact, a lot of guardrails around not like directives not to close anything. And one of the reasons I'm so up to date on a lot of that is a lot of that played out in COVID, right? It's why every judge in the state had a YouTube channel. It's why we're on YouTube today. It's why there are some specific things about Texas state court that make this really hard to do in Texas state court. But that's why I'm asking, and I'm wanting to put some thought into if anybody can bring me anything to show it's ever been done before. I want to afford Mr. Houston's client his proper day in court, but I don't want to do it in a way that basically means we violate law, because then I'm responsible for violating federal law as well. And I don't really want to do that advertently or inadvertently. So I'm in what one would call a proverbial catch-22. And I need some structure from you, Ms. Kelly, if you want to proceed and you want to show that I can do this here. I need a little bit more from you. I mean, you're with the Attorney General's office. If anybody has done this, the Attorney General's office has done it. Even if it's an informal, not a published opinion, but some sort of, Judge so-and-so from the year 2013 did one of these. But right now, I just don't know that we have a mechanism to hear your issue and to proceed in any sort of fair way. Because I can't seal, and I apparently violate federal law if I don't seal.
Right. I'll take your suggestions under advisement, and we'll reset for another day if possible.
Yeah, and maybe in person might take care of some of the issues in this case as well.
Yeah, that was my request. My son is just 4 months old, and so I'm frequently having to pump, and so.
No, I get that, and I totally I'm not saying it was right or wrong. I just think I think that might make it a little bit easier if we were all in a room together as opposed to broadcasting.
Right.
Okay, well, think about that. Let's pick a reset date. Just so you know, Miss Kelly, we have great mothering rooms here at the courthouse.
Okay.
We built that when we built our new building, and it went live in February. And there's a mothering room on every floor, specifically for people in your situation. So it was one thing all the female judges in Travis County felt very strongly about. So
that's good to know.
yes, it's not ideal. I know that it still makes it difficult, but it makes it less difficult, let's say. So let's talk about a date. I think come back to me because I feel like I've engaged on this issue enough and now I'm curious. So let me think about it some more too. But for now, I want to get it reset. And so y'all talk about when you can get it reset and then call Ms. Mesher and we'll just continue this hearing at a later date. I think that's what we're going to do for now, rather than me trying to decide it quickly. Because I just think I'm gonna send it out, just so y'all know, I'm going to send an SOS to some judges here in Travis County as well and see if anybody has dealt with this issue. Because I think I'd be curious if anybody has something dealing with records of these professionals. So at any rate, I'll look into it too, but if you look into it some more as well, and then y'all agree to a reset date and call Ms. Mesher with your reset date.
Will do, Your Honor.
Thank you.
Thank you.
You're excused.
Well, guys, what did you think about that hearing? What it appears to me is that it is a dental professional who was seeking, I guess, treatment for a substance use disorder, and now the licensing body is trying to get the records of those. Very, very interesting hearing. I don't know that we're going to be able to get the follow-up on it because they're planning on doing it in camera or in chambers, but I would love to hear what you think below. I do have some experience in these tribunal type situations from one of my previous jobs, but I really would have thought this kind of thing would have been hashed out a lot earlier. You know, in the agreement between the dentist and the licensing body, I would assume there would be a disclosure agreement set up for these types of situations. So it strikes me as odd that this is perplexing to the court. But anyways, let me know what you guys think down below. I appreciate all your comments and your likes. Yeah, don't be a dick. Give the like a click. Talk to you soon. Bye.